Welcome, everyone, to our latest Antiquities Coalition think tank webinar. I'm Peter Herdrick, co-founder of the Antiquities Coalition, and I direct the activities here at the think tank. Today, we're discussing our most recent policy brief, written by attorney Fionnuala Rogers. She has tackled a very important subject and one with a pressing need for attention and action. Ms. Rogers asks, following the UK's repeal of the EU import regulation in Great Britain, will Northern Ireland become a gateway to Europe for illicit cultural property? In the brief, which you can see at our website, thinktank.theantiquitiescoalition.org, she answers her question with a set of well-conceived and reasoned recommendations to encourage the UK to balance competing interests, meet its international commitments, and take the role as a leading example for other art market countries in cultural heritage protection. To judge by today's attendance, this is a topic of great concern to many in the UK, Europe, and around the globe. I'll turn the proceeding over to our moderator, Alex Herman, the director of the Institute of Art and Law, in just a moment to introduce our distinguished panelists and to leap into the discussion. We have a robust crowd, no doubt full of questions and comments to add, and Alex will make time for those. Please use the Q&A function at the bottom of the screen to communicate your questions and comments. We'll also get a preview of our next think tank policy brief, due for publication next week. Thanks to all participants, and particularly to our author, Fionnuala Rogers, and to the staff of the Antiquities Coalition for their dedication and relentless drive to do whatever we can to combat looting and the illicit trafficking in cultural heritage and to preserve and protect cultural material. With that, Alex, over to you.
Well, thank you, Peter, and thank you to the Antiquities Coalition, Elena and the team for organizing this very interesting and inspiring event. Many of you will have probably read Fionnuala Rogers' excellent policy brief, which was published by the Antiquities Coalition in October of last year. It relates to the UK's repeal of the EU's Introduction and Import of Cultural Objects Regulation 2019-880. And we're going to talk about the repeal and Fionnuala's various recommendations for what the UK should do as a result of that. What I thought I would do before I fully introduce our main speaker, Fionnuala, and of course our two other panelists, Sophie Hayes and Tova Osad, is I was going to just spend a few minutes giving a brief overview of what the EU regulations look like, because I think for many of us, we might not be entirely familiar with their structure. And it's important to understand the structure so that the UK's eventual repeal and Fionnuala's recommendations make sense in that context. So I'm just going to go over a few slides which will help to set the scene on this. I have to thank Fionnuala and the team at Canvas Art Law for creating these slides, which I've very impolitely borrowed. But Fionnuala put these together for an event that we did together a couple of weeks ago. The EU's import regulation had its gestation in 2016 and 17, where there was consultation on the possibility of introducing import controls for cultural objects coming into the EU. Now, the original genesis of this was that it was aimed to combat terrorist financing through the trade in antiquities. But as I think became quite clear later on, it grew into something much broader. So it doesn't necessarily just deal with antiquities that might be traded with the intention of aiding terrorism, but actually is a much broader control of other types of cultural objects as well as antiquities. So the regulation was adopted by the EU Parliament and then signed by the EU Parliament and the EU Council in March, April 2019. It came into force, but not all of the relevant provisions were immediately applicable. So there was kind of a staggered rollout over the next few years. The part of it that's of interest to us, amongst other things, is Article 3.1, and that is a provision that is in force today. It became applicable as of the 28th of December 2020. And Article 3.1 sets out a general prohibition on bringing into the EU territory cultural goods that were removed from their country of origin, contrary to the laws and regulations of that country. Now, the cultural goods that are affected by this provision and by the regulations more broadly are cultural goods that do not originate in the EU. So we're really looking at cultural objects that might have come from other parts of the world and that are being brought into the EU territory. This particular prohibition is rather broad, and we'll look at the kinds of cultural objects that are covered by the prohibition. And keep in mind, as I said, the prohibition is in force today, so it would be unlawful to enter into the EU territory with that material that has been removed contrary to the laws and regulations of the country of origin. The EU has set about providing more detail on the regulations, and the EU Commission has just recently come out with templates and various other details about the practicalities of how this regulation will operate. It says on the slide that the deadline was last year and this was missed. It's actually, I think, just a few days ago that material has now been provided by the EU. The main substructure of this whole system is an electronic system for controlling imports into the EU. That has not yet been set up. It's expected to be established by 2025. Once that's established, then a lot of the other parts of the regulation will begin to apply. So we're still waiting to see what that electronic system will look like and to get an actual date on when that will be operational. The final deadline provided in the EU regulation for when all of this will come together and be applicable is the 28th of June 2025. So we're still more than 3 years out from that happening, but there is, of course, the Article 3.1 prohibition, which I mentioned is already in force today. So that relates to what are known as Part A cultural goods. Part A is found in the annex to the regulation, and it lists out a whole variety of different types of cultural goods, 12 different categories ranging from fauna, flora, minerals, and anatomy in the first category, all the way to articles of furniture more than 100 years of age, including things like products of archaeological excavations, antiquities more than 100 years of age, objects of artistic interest like pictures, paintings, sculptures, engravings, etc. So a huge number of types of objects are covered in these categories. So again, the Article 3.1 prohibition relates to any of these kinds of cultural objects that are brought into the EU territory and that were removed from their place of origin contrary to the laws and regulations of that place of origin. That entry will be prohibited, and that's in force today. Now, there are two other aspects of the regulation that are important for us. These are two aspects that haven't yet become applicable. The first relates to an import license requirement. So for some cultural goods, there will in future be the requirement of an import license. It's quite unusual in the trade of cultural objects around the world that you actually have an import licensing system. Usually countries are more familiar with export licensing for cultural objects, but this is obviously the reverse. So for two categories of items, these are generally considered high-risk categories. There will be a requirement that anyone importing this material into the EU will need to get a license. And so those two categories are, firstly, products of archaeological excavations and discoveries, and secondly, elements of monuments or archaeological sites. So items you could think of that maybe came from the ground in an illicit excavation would be typical sorts of things that would fall into one of these two categories. Now, this requirement for the import license only applies if those items are over 250 years of age. It doesn't matter what their value is, but if they're over 250 years of age and you're bringing that into the EU, you will generally need a license. The second part that hasn't yet come into force relates to other types of cultural objects, much more broad categories of cultural objects, a little bit like the ones we saw in Part A, minus those high-risk categories that we saw in Part B. So anything that fits within one of these categories, again, things like fauna, flora, minerals, historical objects, antiquities over 100 years of age, are objects of artistic interest like paintings, etc., all of those kinds of things. If they're more than 200 years of age and they're worth more than 18,000 euros, then the importer will need to make an importer statement. So not the licensing requirement, the stricter requirement for those high-risk objects, but rather would have to make a statement. So this is how those two aspects look, some of the details. So the import license on the left for the high-risk items, and then the importer statements on the right for the more general categories of objects. Both will only apply once that electronic system envisaged by the regulation is in place. The licenses will be issued by the member state itself, so it's not a EU-wide issuance of import statements or import licenses, sorry. And there will be a requirement for the importer to provide supporting documents showing legal export from country of origin or absence of laws at the time of export. The applications are supposed to either be issued or rejected within 90 days. And then the reasons are generally going to be provided as well if the application is rejected. In terms of the importer statement on the right, that will consist of a declaration that has to be signed by the importer, stating that the object was removed lawfully from its country of origin, and there will be certain details which are soon to be provided by the EU in terms of describing the object. So we're still just we've just seen those. They've just come out recently, so we haven't really had a chance to process them and see what they look like. So those are the two aspects that are still to come into force at the latest by June 2025. There are certain derogations from the rule, whether it's in relation to the license or to the statement, and that would be the case if an item is being brought into the EU and the country of origin cannot be reliably determined, or the item left its country of origin before 24th of April 1972. So in those situations, whether it's for a license or for making that declaration under the importer statement, the application will have to be supported by documents showing that the cultural good left its country, the last country in which it was located, for more than 5 years lawfully, and that it was located in that intermediary country in a way that was more than transitory. It wasn't just passing through that particular country. So that's a derogation from the rule in relation to the license or the statement, but this derogation does not exist in relation to the Article 3.1 prohibition, which I mentioned at the beginning, which applies now as we speak. The reason for that cutoff date of the 24th of April 1972, that's the date that the UNESCO 1970 convention came into force. So that's how that date was arrived at. Now there are certain exemptions. Again, these will only apply to the import license and the importer statement. They're not exemptions that apply to the general prohibition at Article 3.1. So what they say is that the license and the statement are not required if a cultural good is being brought in under temporary admission for educational and other purposes, either by an academic institution or through cooperation between museums and similar institutions. So that's one possibility. Secondly, if the item is being brought into the EU for safekeeping and preservation by a public authority in the event of armed conflict or natural disaster. And then lastly, in the case of art fairs, in certain situations, items can be brought in under temporary admission, and the import license will not be required, but rather an importer statement will be required for those archaeological objects. But if the item is going to remain permanently in the EU, i.e. it goes to an art fair and then is sold to an EU-based buyer, then the import license will eventually have to be obtained. So that's in a nutshell what the EU regulations look like. As mentioned, some of it is in force now, some of it we're still waiting for it to be applicable. But that sets the stage for I think the UK's response and for our discussion with Fionnuala Rogers. So Fionnuala Rogers is a solicitor in England and Wales. She is the founder and principal at Canvas Art Law. She's also chair of the UK Blue Shield organization. So that's the organization that obviously protects cultural heritage in the event of armed conflict. Fionnuala's in a very unique and special position to be talking about these issues because she represents clients that are on the art market side, but she's also very involved in heritage protection. So she has that way of seeing both sides in this particular debate, which I think is invaluable for this discussion and for these policy issues. So with that, I'm going to pass the floor over to you, Fionnuala.
Thanks, Alex, and thanks for doing the difficult bit and explaining the regulations so concisely. That's a great place to start off. If I could actually ask, is it possible to have the timeline slide just on the screen for this first part, if that's possible? Thank you. That's great. So hi, everyone. Thank you for joining. So I just wanted to set out a little bit of context for why I sort of wrote the policy brief, and it is incredibly niche and in response to the UK's approach to this legislation. And just looking at the timeline here, I mean, the UK was never really in favour of this regulation, despite one of the MEPs responsible being from the UK. Throughout the drafting and the debates, the UK had sort of anticipated to leave the EU before it had actually come into force, because of course we were supposed to leave at the end of March 2019. So whilst the UK did vote against it, they probably didn't prepare a huge amount in terms of what they would do post-Brexit, because they didn't expect it to apply. Of course, because of the extension to Brexit, the regulation came into force, and Article 3.1 came in December 2020, before the end of the transition period. And without going into all of the Withdrawal Act and the sort of Brexit arrangements, that meant that part of the regulation became retained EU law. So it applied across the UK wholesale. Now, it wasn't really a surprise that the UK decided that they wanted to do something about this, as they never intended to adopt the regulation in full. But there was a bit of a limbo period where no one was quite sure whether they would leave it in part, whether the whole thing would come in and it would be adopted across from 2020 to 2025, and we'd have a full licensing system, or whether they would repeal the whole thing. I think the surprise came when the government decided that they would repeal the regulation in Great Britain, but they would implement it in full in Northern Ireland. And so it's been included in the Northern Ireland Protocol. And so as far as Northern Ireland will be concerned, they will follow the EU timetable, which is set out on the screen there, and it no longer applies in Great Britain. Thank you, Alex. That's all I wanted to just show the timings. That's great. Now, in terms of the way the UK went about this, it was quite interesting in the approach, because rather than have consultation about the repeal and put this to debate, they did include this as part of the sort of post-Brexit tidy up of redundant EU legislation. And originally it had been put through under quite a straightforward negative process, but that was rejected. And they did say that this had to be repealed through statutory instrument. So it did mean there was some debate, but it didn't get much publicity at all, just because it was in this kind of bulk of post-Brexit legislation. However, by the time it got to the House of Lords stage, there was quite a lot of debate around it, and probably some criticism levied at the memorandum that went with the statutory instrument, that didn't really highlight the Northern Ireland issue, it didn't really consider the impact that this might have on the UK if we had such a different system to the EU and then other parts of the UK, namely Northern Ireland. So there was quite a lot of debate in that House of Lords debate about the effectiveness of UK legislation to tackle illicit trafficking. And it was really that debate and the UK's approach and assurances that sort of spurred me to have a look at this in greater detail. And those points are sort of set out and analysed in the policy brief. I won't go through all of those in full, but a lot of the focus was that the UK has sufficient legislation, and the two pieces of legislation that were cited for illicit trafficking were the Dealing in Cultural Objects Offences Act, and as I'm sure Sophie might touch on later, we've actually, I think we've only had one conviction, and it wasn't an illicit trafficking from a conflict zone. And also the new money laundering legislation. And as again, we'll go into, even though it applies to the art market, it doesn't actually apply to all antiquities and cultural goods. So those two things were cited very heavily as reasons why this regulation could be repealed. And that's why the response goes into that debate in particular in quite a lot of detail. So the objective of the policy brief was to go through and analyse that discussion and those points, and to go on to see whether the UK legislation really was effective and whether we needed anything else, or whether actually we could tackle illicit trafficking based on what we had. And then what I wanted to look at in particular was there a way that we could implement existing legislation or enforce it a bit more practically, so that we didn't have to have anything new. We don't need to bring in new legislation, but we don't need to go as far as the EU, because I think a lot of people who are familiar with the regulation acknowledge that it is quite wide. That list that Alex showed on the screen, it does cover an awful lot of cultural goods, and potentially not the type that would be associated with terrorist financing and criminal activity. So there's been a lot of criticism, and also the documents that are required go back decades. And of course, people might own something completely legitimately, but now not be able to import it into Europe. So there's been a lot of criticism that it's gone wider and it's a bit of a sledgehammer to crack a nut. And so I wanted to look at whether there were ways that the UK could clamp down on illicit trafficking without going that far. So the policy brief makes several recommendations that I'm going to outline in a little bit of detail. Some of you might have read them, but really this is just to explain the thinking behind them. And then I'm sure there'll be plenty of opportunity to discuss them. So the first one was to have dedicated ports of entry for cultural goods that were covered by the UK legislation. And what that would mean is that we would actually say that antiquities need to be brought in through certain ports in the same way that now we have post-Brexit done for CITES. And the reason for that is because I think we all acknowledge customs officers, they don't have the resources or the expertise at every point of entry to identify antiquities, whether they know whether they're genuine or not, whether they would know where they've come from. And I don't think anyone's expecting the UK to put resources into training every customs officer. And they've also got an awful lot more important things to be doing, looking for drugs and arms at the same time. So I think in terms of realistic expectations, the idea of having a few trained officers at dedicated ports might be an option for that. And it would then make it very easy if something came through a different port to say, that's actually not allowed to come in, that's identified as an antiquity or a cultural good, and it has to be redirected or it would be rejected. So that was the rationale behind the first recommendation. And I think in terms of selecting ports, that really would need to come from the art market, because they're the ones who use them every day. They know which ports they use, they know which facilities are at which sort of entries. And so I think whilst the recommendation is there, I'm not proposing to suggest where these ports should be. I don't know where the pressures are. So that is something that would need a lot of consultation with the art market to see how many and what's realistic in that sense. The second recommendation was the information that's required on import. And I've split this into three points as to what might be included. in this recommendation. Now, when you import something, you are asked about the origin. But what we have found in the past is that some people will put the ancient civilization, some people will put the transit country, sometimes the origin is put down and it's accurate. But we have been told from a couple of sources that, you know, customs have sometimes said, if you don't know, just put GB or just put the export country, which might be a transit country. So in terms of looking at whether something was illegally exported from the country of origin, that on its own on the import form really doesn't help. So one of the recommendations was to ask the importer to say why you believe it's from that country of origin. That doesn't have to be that you have an export license. It would be, you know, if you're an expert, if you're a dealer, you probably have an awful lot of reasons why you think it's from that country of origin. There might be comparables you can refer to. There might be provenance that backs it up. But it's really just to set out the state of mind that when you import something and you put the origin, you've said why. And I don't think that's such a huge effort for a professional, because presumably they're importing something, particularly if they're importing it to sell or to exhibit, they probably have quite a good idea of the origin anyway. If you were not a professional and you had absolutely no idea, you would have to refer this to an expert. And whilst that could be extra cost, extra time, and it's a hassle, this is one of the objectives, is to deter people who are recklessly and unknowingly bringing antiquities into the UK, having no idea what they are, and being able to bring them in, because then they don't know whether they're committing an offence or not. Because in UK legislation, it is actually a criminal offence to bring something in that's been illegally exported or illegally removed from the country of origin post 2003. So there is a recklessness element to that offence. I'm sure Sophie will comment on that later. But this was really a way of proving state of mind. The same rationale goes for the provenance element. I think it would be important to list the provenance. Again, it doesn't mean you go as far as the EU and you have to have documents to evidence all of the provenance, but it would be that you actually state the provenance that you've got. Again, it's just to build a paper trail and just to show that when you brought this in, this was what you believed about this object. The other recommendation on information on import was to update the information if you find out later that what you declared on import actually wasn't true. Now, at the moment, if you import something for a particular country of origin, say you say it's from Turkey, and then you do research, you know, several months later, and you find out actually maybe it's from somewhere else, there's no obligation to go back and correct your paperwork. And I think having that as a legal obligation might be a stretch too far, but it could be that it's best practice because there is a mechanism to go back and update that information. And one of the reasons that I thought this was important was that if you import something, say from Turkey, and later you find out it's from somewhere else and you sell it as being from somewhere else, if that piece is investigated, it's very difficult for the importer to prove that they didn't do this deliberately or dishonestly. And I've seen dealers, seen importers and collectors actually get challenged quite harshly and accused that actually they did this on purpose. And of course, we all know that, you know, through research, opinions can change. So that option to correct your import paperwork would be there as well. The money laundering recommendation. So I know money laundering has been talked about in a lot of detail for art market participants and particularly for antiquities as well. The reason the recommendation is there to widen the definition of works of art to include all types of antiquities, including ethnographic materials, is because they're not currently included in the definition of works of art. And that's because the definition was taken from the VAT Act, which didn't have those in that category. And the reason for the recommendation is, again, because now the art market is used to AML. It's got processes in place, it knows how to do it, so it wouldn't be a huge burden to include those. But also because the UK government placed so much emphasis on this being used as a tool to clamp down on illicit trafficking, that it does make sense that we include all types of cultural goods within that as well. So that would be change to the legislation in AML, and I know the government are consulting on that now, and we do think that there might be an amendment to that effect coming forward, though we haven't had confirmation of that. And then the final recommendation was really to the point about the breadth of cultural objects that are covered, and a way to potentially resolve this. Now, I think the reason that the EU had such a wide list of objects was because any of these could be foreseeably used for terrorist financing and criminal activity in the future. I don't think we can rule it out. These are all cultural goods, even if they're not something we associate with conflict and terrorist financing at the moment. But in terms of high-risk objects, I was looking at the way CITES is dealt with, where they have different categories, and there are COPs every so often, every 3 years, I think, and they assess the risk to certain types of objects. Another alternative would be the ICOM red lists, which regularly look at the objects that are most at risk of illicit trafficking, and they require enhanced due diligence. So this one, again, would need a lot of consultation. I don't think it would be as straightforward as CITES, because of course CITES, it's the specimen rather than a particular country of origin. But it might be that if there's a very narrow category of objects that are chosen, this mechanism could be in place to expand it if needed, if there is evidence of illicit trafficking of a certain type of object, a certain country, without having that as the blanket policy across Great Britain. So those are the sort of explanations as for why the recommendations are there, and a bit of context. And yeah, happy to discuss and be critiqued.
Well, thank you, Fionnuala, for setting that out so clearly. Just to remind people that if they want to read the policy brief itself, you can find it on the Antiquities Coalition website. It was published in October of 2021, policy brief number 9. So you can read all of this and the recommendations, the 4 recommendations that Fionnuala just outlined for us just now. So thank you very much, Fionnuala. That was very interesting. And I think we should get in our panel of experts to discuss some of these recommendations, because I think that can provide some insight into each of those. So the first recommendation that Fionnuala mentioned was to have dedicated points of entry for antiquities coming into the UK. So I thought maybe we would start with Tova. So let me just introduce Tova Osad. Tova is the founder of Osad Arts Management. She's worked in the art business for quite a long time and is an expert on import, export, and transporting cultural goods internationally. She has a master's also from the Courtauld, which puts her in very good stead in our art law circles. So Tova, any thoughts on the points of entry, having dedicated points of entry for antiquities?
Well, first of all, thank you for having me, and thank you for inviting me to join. So in thinking about dedicated points of entry, Fionnuala is absolutely right. There are specific ports that the art market uses that have a lot of traffic going through them. Specifically, Dover is the best example. I thought about this a lot when considering the brief, because having worked on, and I work a lot with the art market side, you talked about Fionnuala having the 2 coins. I'm very much on the art market side of that coin. Thinking about the points of entry, I have a lot of, not issue, but questions about how that can actually be managed. The biggest problem with a lot of these ports is that they have so much material going through it every day. And this was a huge consideration when Brexit actually happened. And I think we can all remember those photographs of the queues at Dover, of the trucks going on for miles. And I worry that if something like a dedicated port would come into place, how would that actually be managed? Because right now what's happening is that a lot of material is just going through the port and then subsequently being declared with a customs declaration. It is not necessarily inspected at every turn, which I'm sure Sophie will say is part of the problem and not any way interested in a solution. But and I think that it also doesn't consider the fact that a lot of dealers, dealers who are not the big names, but the smaller dealers who are used to getting in their cars, driving into Europe, filling up their cars with inventory and coming back. Now they can't do that. So they're looking for alternative methods of transport that are not as expensive as using a specialist freight forwarder, which means that they use UPS, FedEx, DHL. So how do you then tell FedEx, UPS, and DHL to use a dedicated port to check something? So I think there are logistical issues with this point that I'd love. I mean, I don't know if Fionnuala, you've thought about this or how to sort of work it through, because my concerns are resource. My concerns are, resource both on the customs side and also the dealer's side, and collectors who are trying to bring things in to the best of their ability. How do they do that if there's a dedicated port? I see difficulty there.
Just a question on that. How does it work in your experience with CITES, so with endangered species? Just because that, I think Fionnuala in the policy brief makes a comparison with the CITES points of entry.
Yes, and actually that's a great sort of looking back at CITES is actually a great example for something like this. In my experience, it is complicated, I think is the nice way to put it. CITES licenses take a long time. It's arduous. It means that a lot of nothing moves quickly, which for the art market is always difficult. But also there aren't as many, especially in the art market, in the art world, in my experience, there aren't as many CITES licenses that are coming through, especially now that ivory is no longer a part, we can't import ivory anymore, and since the ivory ban, which I'm not claiming I know anything about, and Fionnuala can correct me, but since that, a lot of the CITES it hasn't really happened as much. So it works, but I think in my experience, it's not a carefree, easy system, I guess is the best way to put it.
Okay, thank you very much, Tova. Very, very useful insights. So with the second recommendation, I'm going to turn to our second expert on the panel, responding to Fionnuala's policy brief, and that's Sophie Hayes. Sophie is a detective constable with the Metropolitan Police in London. She works in the Art and Antique Unit, and she has a master's degree from the University College London in Cultural Heritage Studies. So she understands the area and obviously understands the law as well. I wonder, Sophie, if we could turn to you on the second recommendation from Fionnuala's policy brief, on the question of various information points that could be added by an importer at the point of entry. What your thoughts are? Fionnuala mentioned this could be of use perhaps in relation to proving state of mind if there is an investigation or a prosecution down the road. What is your take on that sort of information being more readily available in future?
Oh, well, first of all, I'd like to say thank you. It's wonderful to be able to contribute to this discussion on such an important topic. I'm in favour of a declaration because I think, as Fionnuala says, most dealers and most experts will have that information already. They will know, they will have conducted research, and then therefore I think asking them to write that down is not that onerous, because they will have expectations and reasons for believing in a particular object's country of origin. And I think it works, I think it's beneficial in two ways. As Fionnuala says, the police can end up investigating an object many years after it was imported. And I think it both provides me with a paper trail that I can then interrogate, looking for evidence that points either towards or away from a person's involvement in criminality. But also it gives the dealer some paperwork to fall back on and say, look, this was my state of mind, this is why I thought it. And so it also gives then some pushback about an explanation for what they've said and why they've said it. So I think having a paper trail is really important, because it's amazing how many objects have absolutely no paper trail at all. And that's a very poor starting point for an investigation.
Thank you. Thank you very much, Sophie. Tova, I wonder if you have any thoughts on this second recommendation. So providing that information at the point of import. So that would include the believed origin, a declaration by the importer that the item had not been illegally exported, provenance information, and then Fionnuala also mentioned possibilities of updating that information if more evidence becomes available after the import. Do you have any thoughts on that process?
Yes. So, and I think Fionnuala mentions this in the brief, in logistics, and when you are importing an antique, so a commodity code of something that's over 100 years old, well, now 250 years old, according to the new UK GB commodity codes, you have to provide an antiques declaration that says that the object that you are importing is believed to be over 100 years old. And I actually think that that's a good template for what we're trying to do here. If there is if dealers, collectors are given recommendations about what the paperwork needs to say, so that you can say, yes, I believe that this item is from Turkey, using Fionnuala's example, I believe that this is where it's come from, I'm importing it according, I believe to be importing it on this date, or something to that nature, then you are providing Sophie and Fionnuala with that all-important state of mind. And also attached to that, I think the update system, and I thought a lot about what we can actually do about updates. It's difficult because to update a customs entry, you need a customs agent to help you with that. And that becomes expensive because the freight forwarder uses the customs agent, and that ends up creating a lot of cost. Whereas if you add to that declaration and you say, well, what I thought was from Turkey is actually from somewhere else, then you're providing the sort of proof of state of mind that you have something dated. It's not as strong as an affidavit, which I think people get nervous about, especially if it's a question about study. A lot of dealers are experts. They bring these things in, they think they know what they're looking at, and then they research it themselves and they understand it better. So I think that the possibility of that, and I'm sure Sophie and Fionnuala can say whether or not that actually works, would create the one side of the all-important paper trail state of mind, and the other side of, I'm trying to keep within the regulations here, and I want to make sure that I'm doing my due diligence. So I don't know if that as an idea would work.
Great. Thank you very much, Tova. Very, very interesting. I'll move on now to the third recommendation that Fionnuala made, and that was about the anti-money laundering rules and expanding those so that art market participants would also include those dealing in antiquities. Currently not the case. Maybe Sophie, this one for you. Do you have any thoughts on that particular gap that exists now, and whether this would help generally in policing the antiquities trade?
Yes, absolutely. I'll just return to Tova's point first about, we very much, especially in the art and antiques unit, we specialise in investigating cultural heritage crimes. And we really recognise that the reality of the art market is that opinions do change. Research changes. When someone's physically got an object in their hands, it can really change their opinion of an object and their understanding of it. And I think that is the reality, and that is understood by law enforcement. I think when you write a declaration, it's not necessarily committing that that's what you will always think forever, but it is about saying what your state of mind was at the time. And so I think the opportunity, or at least some audit trail documenting that change of opinion would be really helpful. I think that would be a really positive thing. So returning to AMLD 5, I would personally be in favour of expanding the definition, because I think at the moment it's quite restrictive and it doesn't include a lot of items that lay people would expect to be included in regulation of the art market. But I don't think really that a restriction is only applies to antiquities. I also think there's a big hole at the moment because digital art isn't covered. And I think that's a big opportunity for money laundering. I'm sure we've all heard a lot about NFTs, and I think there are holes in the legislation at the moment, and we shouldn't accept the legislation as it is at the moment, but really tighten it because it is hugely useful. And also anti-money laundering legislation, unlike cultural heritage legislation, is very compatible between international jurisdictions. So it is a particularly useful tool for law enforcement.
Thank you, Sophie. I was hoping that we could get through an entire seminar without mentioning NFTs, but of course it was doomed for failure. Anyway, thank you. Very interesting points about the money laundering using different forms that aren't currently covered by the AML rules. The last recommendation in Fanula's policy brief was, of course, this categorization of high risk objects coming in, or delineation of different types of risk. I wonder, Tova, maybe I could turn to you and just see what your thoughts are on that. Is that workable from a practical perspective?
Well, I think that's already started. There are new commodity codes that have come into effect as of the 1st of January. And within the antiques commodity code of 9706, there are subcategories now of objects over 200, and there's 250 years old. And I think that that's the start. I mean, 250 years, I think, is a specific number, that it is in response. I mean, this is I don't know, but this is my feeling, that is in response to some of these regulations. And I think that that's already begun. How to do this, and I know Fanula mentioned the sort of, in the brief, mentioned the idea of emergency high stakes. I think that becomes a bit more difficult because then you have to make sure that everybody's notified of that. And again, it goes into, you will run into that, oh, well, I didn't realize, and the state of mind question keeps coming up, I didn't realize, it was an honest mistake. I didn't realize that, I was about to say Iran, but of course Iran would be on there. But Lebanon has come off the list and now it's back on again. I wasn't aware of that. I'm really sorry. How far can you go with that? So I think that becomes the emergency categories become a bit more difficult to regulate. But I think we're on our way to looking at what are high risk imports. So.
Thank you very much. Sophie, how about you from a law enforcement perspective? Is that something that could be useful down the road if you're investigating or potentially there's a prosecution, having these different categories?
I think it's a really interesting idea, and I think being able to identify something as high risk would be particularly useful for example, dealers when they're conducting their own risk assessment for AMLD. The problem is, I think that the art market, or some aspects of the art market, can move very slowly. And we do see evidence of pieces ending up in transit countries for years before they come to the UK. So I think really immediate conflict followed by immediate arrival in the UK, whilst it could happen, isn't necessarily the only model. And so I don't know how long you would keep those restrictions in place. For example, if there was a conflict, would you keep those restrictions in place for 10 years? Is that proportionate to the risk? So I think the actual implementation would potentially be quite difficult. And I also think you're potentially asking quite a lot of the customs officers if there is a sort of changing inventory of what is high risk, because people's background is law enforcement rather than necessarily archaeology. And I think it would be quite a challenge to ask people to detect those false declarations.
Great. Thank you very much for your comments, both of you, Tova and Sophie, on the specific recommendations from the policy brief. I wonder if we could go back to Fionnuala. Do you have any thoughts on what you've heard? Do you like the responses? I think they generally show that the recommendations are aimed in the right direction and could achieve some good if they were taken up by government. Your thoughts, Fionnuala?
Yeah, I mean, it's really useful because these are kind of initial recommendations to be explored. They're not supposed to be fully developed, let's go tomorrow, put this in place. They need discussion, they need consultation, and we do need to work out, the balance between what impact that would actually have on illicit trafficking against any sort of extra burden that is placed on the art market. Because, these recommendations that is just what they are. They are recommendations for taking forward. I don't necessarily think that all of them are needed. I think we could probably make an impact with one or two of them. And it sounds like from the practicality side of the art market, this sort of information on import might be quite easy to do for those who are sort of professionals and are most likely to be affected. It might be a bit more of a burden for someone who knows nothing about what they're importing, but then that's the type of person we're actually trying to affect, because we are trying to deter people from kind of blindly bringing in cultural property that they know nothing about, whereas the impact on the art market might be quite negligible. But from the discussion and the response from Sophie, it sounds like for an investigation, that would make quite an impact. So that's the one that I feel seems like it would make quite a difference. And then the AML one, as Sophie has said, would also be quite useful. So yeah, encouraged, but certainly not suggesting all of them need to be in place for an impact to be made. I think a couple of them being taken forward would really be a great achievement, and perhaps create something a bit bespoke, because we must remember that we are in a slightly different position than the EU. We are, the second biggest art market. As well as having to clamp down on illicit trafficking, we do have to protect the art market as well. So that balance has to be right.
And can I just also add, that I think that the dealers who I know and the art market and the collectors who I know take their responsibilities as importers very seriously. They know that their companies, that they are responsible for the objects that they bring in, and it's very important to them to get it right. And the questions about state of mind, that plagues a lot of dealers. They get nervous about it because they want to make sure that they're doing the right thing and keeping their inventory, their reputation safe. So I think that that's really important to keep in mind as we think about recommendations and the effect on the art market, because they are these dealers are experts. They know their fields, and they really want to keep this art market alive. So it's wonderful to talk about the different ideas and consult about them, because that's really the goal of everybody. So just.
Fionnuala, what would you say to someone who reads your recommendations and says, it looks like this is the EU regulation which the UK has repealed, coming in through the back door? Because I mentioned in the introduction that the importer statement in some respects is about making a declaration and having documentation to back that up. How would you respond to that person?
Well, there's a couple of things, I suppose, and it's I think when we talk about what the declaration would be saying, we need to think carefully, because I think we'd be saying that it's not, rather than unlawful export, we'd probably be linking this to UK legislation, given where we are now, and saying that, they don't believe that the object is tainted under the 2003 Dealing in Cultural Objects Act. So the 2003 date would probably be the date to use, whereas the EU date goes much, much further back. And it's already a criminal offence to import something that was tainted after 2003. So it's just asking, why do you think that you're not committing a criminal offence? The other point is that the EU system, even though it's a declaration rather than a license and it's an importer statement, the rules set out that you have to have the documents. You don't have to submit them unless you're asked, but you have to have them. So really the difference between the license and the importer statement in the EU system is about administrative process. It's about the cost and the application process. It's not about the evidence that you have in your possession. You have to have it, whereas a declaration as to what's your knowledge and belief, you don't have to have documents to do that. So I think it would be more flexible.
Great, thank you. A big part of your policy brief, of course, dealt with Northern Ireland and the fact that Great Britain has effectively repealed the EU regulation, but Northern Ireland, it would still apply there because of it falls within the protocol between the UK and the EU. I wonder if you could just take us just briefly through what the issue is there, what the risk is that you foresee potentially with Northern Ireland.
Yeah, so I think the risk, and you know, we get a lot of people asking, is there any evidence? Well, no, not yet, because actually the licensing system's not in place yet. So the issue with the EU kind of imports isn't yet in place. But I think the risk is that the UK's approach is to not change the way it handles cultural goods and the import of cultural goods. So it is required to implement the licensing system, but it is sort of implied that maybe it's not going to, which is quite worrying. That might change between now and 2025, of course. But what that would mean is that given the UK's desire to minimise checks between GB and Northern Ireland, objects could be, you know, imported into the GB and then through Northern Ireland into the EU, where they can't otherwise get a license to get into the EU. So there's definitely a risk that people trying to bring things to the EU, they fail to get an import license and they take them through a slightly weaker border check. You know, this is people who are dishonest and are deliberately trafficking material. So, you know, falsifying documents, that kind of thing. I think that is a very real risk and one that unfortunately the UK is left with the responsibility for.
So how do you see that being addressed potentially, either through the recommendations or is there anything else that you would recommend for the UK government to take seriously to avoid that potential risk?
I mean, that would probably involve me being able to solve the Northern Ireland Protocol problem. So I'm not even going to try and go there. But I think bringing the sort of the system and the statements and the information that's required on import into GB kind of closer and having more stringent checks would make the risk slightly lower, because if you did have to give this information and this state of mind when you brought things into GB, it's not a sort of no questions asked jurisdiction where you can just bring things in. So I think that would still show that the UK is taking its obligations seriously, and it's not a place that you can bring, you know, illicit objects easily and nobody notices, and that would be a huge part of it. But in terms of the checks between GB and Northern Ireland, your guess is as good as mine, I'm afraid. That's a huge issue, and I'm sure Tove struggles with this on a daily basis.
Yeah, Tove, do you have any thoughts on the Northern Ireland risk, just in terms of the practice right now?
I only know how to do it the right way. You'll be happy to know. So I'm not aware of gaps yet. Yeah, I wish I had more insight, but I can't, because I know you know, you declare it, go, you know, you move things, you declare them correctly, you know. I tell my clients to do things the right way, so that's the way that I know. I wouldn't begin to imagine how it could be trafficked, but that's not, you know, because Sophie, you'll be happy to know I do things the right way. So I don't have, I wish I had more insight, but to be honest, I don't.
I mean, the difficulty is here is that the UK wanted to avoid having to engage with the EU licensing database and the system, that if Northern Ireland stays within the system, the checks are supposed to be carried out in England. So it's going to have to engage with this anyway. And, you know, unfortunately, that's sort of a burden that they will have to take on board. The London art market might not have to deal with it too much, unless, of course, they're importing into Europe. Or Northern Ireland, but certainly the UK government's going to have to take this one and figure out a way of how to kind of engage with this database system.
I suppose that will only really become a major issue once the system's in place in the EU. We said, you know, that could be at the latest June 2025. So we hope, I suppose, that the UK can get its house in order before that, before it all comes into play when the system is live in the EU. I thought in the last few minutes that we have, we could address some of the questions that have come from the floor. So I'll just read these out, and then if any of you want to jump in, feel free. There were a couple of questions about the AML directive and why it would be necessary to include those dealing in antiquities as art market participants. Maybe anyone want to jump in on that, just in terms of why the definition did not include them, maybe something on that, and then also a question about what evidence there is that expanding it to antiquities dealers would be a reasonable thing to do. Who wants to start? Fionnuala, maybe? Do you have any?
Well, in terms of why it wasn't included, it's really down to the definition in the VAT Act and the specific clause that actually what a work of art means. And there's a part in the VAT Act that says a work of art is not, and it goes down and it excludes, I think, ethnographic material and certain other collector's items. So I think the reason that it's been perhaps overlooked is that in the AML legislation, there's a sort of specific provision that for cultural goods, there's enhanced due diligence for things like antiquities and cultural goods, but that only applies if you're an art market participant in the first place. And an art market participant is somebody who's selling a work of art, which then excludes these particular items. So it's it's quite a complex circular issue. I think it probably, from my discussions with sort of certain government departments and things, I think some areas of government probably weren't aware of this, and certainly in the House of Lords debate, those who were using the AML legislation specifically covering antiquities were not aware. So I think this has been missed and overlooked. I don't think it was deliberate on that part, but in terms of the evidence question, I'm going to defer to Sophie.
Well, I agree, of course, with Fionnuala's explanation of how antiquities came not to be included. But I also think we need to look at the AML regulations more holistically. It's not just about the object. It's also looking at where the funds to buy that object are coming from and where they're going. And so if we think about the art market being used as a vehicle to launder money, which clearly there's been the decision that is a market that needs to be regulated, hence the introduction of the regulations. I think it's almost perverse to pick specific categories of what would be traditionally perceived as art to then be exempt from that regulation.
So you see it, Sophie, more as an oversight in a sense, the fact that the antiquities trade was not included in the broader category, rather than anything based on a particular policy decision at the outset.
I think that yes, I do, because I think as Fionnuala said, it was drawn from the VAT Act, that actually it was taken from a particular subsection of the VAT Act, and I think that meant that quite a lot of important things like numismatics, like collectible items, like antiquities, were not included. And I think there's no reason to believe that the funds being used to acquire those items, or where those funds are going, are any different to any other aspect of the art market. So it seems unusual that they would be less regulated as opposed to equally regulated.
Okay, thank you. And then we have a couple of questions from VJ. One of them is about temporary import permits. Permit may be referring to the EU, I'm not sure, but could we just, anyone have any thoughts on just temporary things coming in on a temporary basis, and whether the kinds of recommendations you made, Fionnuala, would apply there as well, or is this really more about permanent importing into the UK?
It's a really good question. I mean, the EU system is not going to apply to temporary imports, but I think if it was the recommendation as to why you think it's from this particular origin, I don't see why we wouldn't have that for temporary imports as well, going to the point that Vijay makes, that, you know, sometimes these goods stay for an awfully long time, even though they were temporary. So I don't think the burden would be any greater because you're bringing the object in for a reason. Again, if you're a professional and you know what you're bringing it in for, I think that's fair to have the provenance stated. So I think certainly those measures could apply to both. And I don't see why that wouldn't be the case.
There are different types of temporary imports.
Such as?
So do you see, well, particular to the art market, 3 come to mind. The first is a bonded warehouse where items are kept within for an extended period of time in a warehouse that is specific for non-entered goods, so non-GB goods. So that's number 1. Number 2 is a temporary admission, where a lot of galleries and art advisors hold accounts with HMRC, which mean that they can have items in their shops for exhibition and public display for study and sale for a period of 24 months. So that's number 2. And number 3 is for restorers. It's called an IPR, inward processing relief, which means that anything that comes in to be restored from outside of Britain goes onto the restorer's account. And it's the restorer's responsibility to make sure that it is, and this has to, that it is well looked after and doesn't sort of disappear into the ether. And the idea being that if items are brought in under temporary import, either through temporary admission or bonded warehousing, they can't be altered in any way. There are lots of specifics about that I won't go into, but with IPR, they can be restored. So I suppose the question, you know, if something is coming in on IPR, do we need a restorer to, who's sort of taking on the responsibility of the object, but if it's not him, it would be somebody else. It's actually about the dealer who's bringing it to the restorer. You know, should the restorer then be responsible for these statements? You know, where does the responsibility go? How does it, because even though it's the restorer who's on the paperwork, it's not really about him or her, it's about someone else. So that's why I asked, what are we thinking about different types of temporary import? Or are we focusing on the bonded warehouse and the temporary admission, which are specific really for storage and possible sale?
And I would say in response to that, actually, that I think it would, I don't see why any of those situations would be exempt, because again, going back to the existing UK legislation, you know, importing something and this is a criminal piece of legislation. So I think we shouldn't be bringing things in, not knowing where they're coming from, regardless of whether they're going into long-term storage, whether they're going to a restorers. And certainly in terms of how the EU system works, they've expressly covered those scenarios, such as, you know, storage. They've covered free ports, that kind of thing. But I suppose the other reason is because I guess the criminal legislation, I mean, Sophie, you'll maybe comment on this, but it doesn't exempt these situations. You know, if you're bringing in something illicitly, dishonestly, the fact that you're bringing it in for restoration doesn't get you out of your criminal offence.
No, it wouldn't be an exemption. And actually, again, if we look at the proceeds of crime legislation, I can think of examples where that could be really easily applied to restoration, something like converting or disguising criminal property. So I think it makes sense for it to be applicable in all those three situations.
Great. Well, I think we'll have to draw our discussion to a close. Thank you very much to the respondents. Thank you, Sophie Hayes, and thank you, Tova Osad. And of course, thank you to Fionnuala Rogers for presenting her policy brief. Again, everyone should read it. It's available. I think Elena put it up on the chat box, but it's available on the Antiquities Coalition website. Really interesting policy piece, and hopefully one that can have an impact going forward in getting the powers that be in the UK to think long and hard about these issues before proceeding to the next step. So thank you again to the panel. And it's now my duty to pass us on to the speaker for our next talk with the Antiquities Coalition, and it's Heide Dickstall. Heide, the floor is yours. Do you want to tell us about what we have to look forward to?
Well, thank you, Alex. And first of all, Fionnuala, congratulations on your paper. That was a very interesting discussion. My name's Heide Dijkstall. I'm a barrister practicing international criminal and human rights law at 33 Bedford Row Chambers in London. My upcoming policy paper addresses cultural heritage that is impacted, damaged, or destroyed by activities such as large-scale development projects and exploitation of natural resources, which lead to environmental damage, abuse of land acquisitions, and in times result in displacement of communities and groups, and disproportionately indigenous people. The paper examines whether international criminal law and the international court might provide victims of these acts with a remedy to achieve justice and accountability, as well as create deterrence. The destruction of cultural heritage is often associated with war and armed conflict. And before the ICC, the available crime under the Rome Statute, which specifically addresses cultural property and heritage, is a war crime. Therefore, it only provides a specific remedy for actions against cultural heritage perpetrated during a war, during a conflict. And this reality leaves a gap in recourse when cultural heritage is harmed during times of peace. For this reason, the paper explores the link between environmental crimes, the destruction of cultural heritage, and the crimes against humanity of deportation and forcible transfer before the ICC. Through this link, the paper recommends that the crime against humanity of deportation and forcible transfer be explored and utilized to protect cultural heritage by examining instances where these globalization activities outside an armed conflict force people from their lands and destroy the land and environment which is integral to their cultural heritage. So the paper, which is due to be published on the 9th of March, fully examines this proposition by setting out how the crime against humanity of deportation and forcible transfer might be applicable, by raising ICC case law on not only attacks on cultural heritage, but also the crimes against humanity of deportation, and looking to specific examples of communities and indigenous groups impacted by globalization activities, which cause environmental damage and forced populations from their land closely linked to their culture. So thank you very much to the Antiquities Coalition for publishing it. And I hope everyone that reads it finds it informative. And I'll hand that back to you now, Alex.
I think we're at the end of the event. Thank you very much, Heide, and thanks again to Fionnuala Rogers and to the panelists. And unless there's anything else from Elena or anyone at the Antiquities Coalition, I think we'll call it a day. So thanks again.